Hi folks, and welcome back to Conveyancing. This is video 3 in the video series on remedies, and in video 1 we had a look at the remedies available and election, termination. Video 2 we covered damages and specific performance, and in this video we will look at deposit and misrepresentation. So very quickly looking at the issue of deposit. As we already know, the deposit is an earnest or bond for performance. If the seller terminates for the buyer's default, the buyer is going to forfeit their ability to recover the deposit. Where the seller defaults and the buyer terminates, the buyer can recover either through an express contractual right, like 2.4, and I've set out 2.4 there for you, or via a claim for money had and received, and on the basis that the consideration has totally failed, and you did total failure of consideration in your contract law unit. That should hopefully be ringing some bells there. So under clause 2.4, it helps us, it sets out the machinery for helping us work out who is entitled to get the deposit and when. So the party entitled to receive the deposit is, if the contract settles, the seller, obviously, because it's part of the actual purchase price. If the contract's terminated without default by the buyer, then the buyer gets it back. And if the contract is terminated owing to the buyer's default, then obviously the seller gets it. So all spelt out very nicely and neatly in 2.4 sub 1. Any interest goes to the person entitled to the deposit. And under sub 3, if the contract's terminated, the buyer has no further claim once it receives the deposit. This is the sub that we looked at just previously. And we know about investing the deposit at the risk there. So just a couple of specific issues to raise with you, just for your own noting. In terms of the buyer, there is an issue where case law had established that if a buyer had contractually given away the right to object to a defect entitled by the seller, you arrived at this rather odd situation where, because the seller was in breach and had a defect in title, the seller couldn't request specific performance, but at the same time the buyer's given away the right to object, so the buyer can't get their deposit back. So you've kind of got this odd stalemate situation happening. That's been rectified by 69 sub 1 of the Property Law Act. And that says where specific performance wouldn't be enforced by a court because of a defect or doubt as to the vendor's title, but the defect or doubt doesn't entitle the purchaser to rescind, the purchaser can still recover the purchaser's deposit and instalments and be relieved from liability under the contract. So that's 69 sub 1 of the PLA there that's rectified that little odd quirk of the case law. The seller's issue, well, no real issue, I guess. They can obviously retain the deposit under Howe and Smith if the contract's terminated for buyer default. What I did want to flag for you is that this is still the case even if there's non-compliance with Section 59 of the Property Law Act, and that is the formalities section that requires writing and so forth. So even though your contract might be non-compliant with Section 59 PLA, you will still be able to retain the deposit. Other than that, clause 2.4 of the REIQ will govern if you're happy enough to have a standard contract working in your favour there. So that is the issue of deposit. And the final issue that we need to talk about is misrepresentation or misleading or deceptive conduct. And look, we went through this stuff ad nauseum really in your contract law unit, so you should be very, very comfortable with all of this. Just a few things that you do want to flag, I guess, for the purposes of this unit and specifically in terms of remedies. Rescission is the remedy that you're going to be seeking for misrepresentation at under your common law. And you can also get rescission under the Australian Consumer Law for misleading or deceptive conduct. But obviously that is a statutory remedy rather than rescission being the usual equitable remedy. In terms of rescission in equity, we know that it unwinds the contract. We've just talked about that in an earlier video in this video series. Orders are made to restore the parties to their status quo ante. We know that there are certain bars that will apply And we know that it gets progressively more difficult to claim rescission as you head towards and after registration. Certainly after registration, rescission is not possible, and you're going to actually have to try and seek an order for reconveyance there. So that's rescission in equity. Under the ACL, again, this is just a bit of a recap. The remedies for misleading or deceptive conduct under the ACL, you will recall, are found in section 237 and section 243. Section 237 is the gateway provision that allows the court to make the orders it thinks fit against the person who has engaged in a contravention of Chapter 2, and the misleading or deceptive conduct provision is in Section 18, which is housed in Chapter 2. So this is the go-to provision that gives the court the power to make the orders, and then you'll see down there in Note 2 the orders state that the court may make include all or any of the orders set out in Section 243. So then you've got to wander over to Section 243, and that tells you all of the orders that can be made. Now, in terms of rescission, there's a stack of great orders that a court can make that are quite nifty and can be tailored to fit the circumstances quite well. But just in terms of rescission that we're talking about right now, you'll see I've got the red arrows there. So without limiting 237, the orders that a court may make include all or any of the following: an order that the whole or any part of a contract made between the respondent and a person who suffered loss or damage referred to in that section is void. So an order declaring whole or any of a part of the contract is void, and if the court thinks fit, to have been either void ab initio or void at all times on and after such date as is specified in the order. So much more flexible than just the good old garden variety equitable rescission remedy there. You can actually tailor it to operate from a specific date if the court thinks fit. As I said, there's all sorts of other nifty things in 243 that you can ask for. I will leave you to explore that provision at your leisure. So that is rescission. And in terms of damages, where your client is claiming misrepresentation at common law and they are seeking damages, the damages that they are seeking will be damages in tort, not in contract. They'll be seeking damages for the tort of deceit, and these are calculated in a very different way to damages in contract. So the tortious measure of damages, according to that, the court will try and put the applicant in the position as if the tort had not been committed. So the court will ask how much worse off the plaintiff is after entering the transaction as compared to it never having taken place. That's the City Mutual test. And generally speaking, the plaintiff's going to be able to recover the amount spent in reliance on the conduct, not the amount of profit that they would have expected to make if the contract had been carried to completion. So the usual measure that will be adopted for damages in tort will be the difference between the value, the actual value of the property at acquisition, and the amount that the plaintiff paid. And that is what the plaintiff will receive as damages. And you can claim consequential losses there much as you can under contract. Okay, so that's your damages in tort if you are claiming misrepresentation of common law. If you are claiming under the ACL for misleading or deceptive conduct, then section 236 is your go-to section, and that says if a person has suffered loss or damage because of contravention of chapter 2, you can recover that amount by suing the other person. In terms of the way that this provision has been interpreted over the years, originally, because this what was the Trade Practices Act and is now the Competition and Consumer Act, and here the Australian Consumer Law, it's all about the consumer. In Henville and Walker, it was held that it didn't really even matter whether or not the plaintiff had bothered to check certain facts that would have enabled the loss to be significantly minimised. Now that position has been ameliorated somewhat under Section 137B. We do have a contributory negligence provision that will apply to actions on Section 18, misleading or deceptive conduct. So you do need to now figure out whether or not the plaintiff has to some extent caused their own loss. Generally speaking, damages under 236 will be calculated by the difference between the market value at the date of contract and the price that was paid. So much like the tortious measure at for common law actions of misrepresentation. If the contract is rescinded, then you're not going to get that measure of loss because you've gotten yourself out of the contract that was causing your woes, but you may in fact still claim consequential losses. Also, you need to be aware that if you're acting for a plaintiff, you can claim accessorial liability against other parties that might have been involved in the contravention of Section 18. And this is where you get the finger being pointed at the seller themselves if they have been knowingly involved in the contravention of Section 18. We did cover accessorial liability earlier on in this unit, so if you need to go back and revise those provisions that we discussed earlier on. So that is damages under the ACL, and that is misrepresentation. So that is the suite of remedies that are available for disputes and termination, rescission under a contract for sale and purchase of a property in Queensland. And that is the end of this video series. And as I always say, if you have any queries or questions, please don't hesitate to contact me. Apart from that, I look forward to chatting with you in a Zoom tutorial sometime soon. And apart from all of that, thank you very much for watching this video series and indeed all of the video series for the conveyancing unit. If you have any feedback, I would love to hear it. Please leave me a comment or email me, tweet me, Microsoft Teams me. And it's bye for now, guys. Thanks again.